Welcome once again. In this series, we are looking at answering um, essay questions, what students normally will regard as essay questions. So, I have some questions here on the law of thought that I want us to just use as a case study. A question says the general rule is that there is no liability in negligence for damage caused by the defendant's failure to act. I repeat, the general rule is that there is no liability in negligence for damage caused by the defendant's failure to act. Critically examine the accuracy of this statement. So this question says examine the accuracy of what has been said. So I would expect that the examiner will be testing whether you agree with that statement or not. Do you agree that this statement is correct, is a correct position of the law? But sometimes the statement may not be a correct position of the law. So you start by telling us that yes, this statement is actually true, or this statement is not true. Now it says no liability in negligence. So you know that it is talking about the tort of negligence. This exam is about the tort of negligence. I mean the law of tort rather. And so no liability in negligence for damage caused by the defendant's failure to act. As a student of tort, of course, you would know that ordinarily most of the cases we deal with where the defendant is acting, is doing something positively, but liability for failure to act, omissions, to omission to act, you define the context of your answer. What does the statement really mean? Okay, failure to act could mean, for instance, refusing to rescue a drowning man, not assisting a child to cross the road, not being your brother's keeper, so to say. And so you tell us the position of the law. Is there liability for failure to act? Is there no liability for failure to act? If there's no liability for failure to act, is it an absolute rule? So the question we expect you, because sometimes in most cases you have the general rule and you have the exceptions. Are there situations where there will be liability for omission to act? So it's not for you to say, because the question says critically examine the accuracy of the statement. Tell us about the accuracy, whether it is a representation of the law, then tell us also if there are situations where the statement will not be accurate, and then you'd be able to go. I also have a question that says the courts have made it clear that liability for nervous shock does not entirely depend on foreseeability of such shock. A student that has studied this field would know that we are still talking about liability in the tort of negligence. And so if it says that liability for nervous shock does not depend on foreseeability of such, what is foreseeability? What is nervous shock? Define your terms. Explain what is meant by nervous shock, and then tell us what is foreseeability. Of course, as student of tort, you know that foreseeability is key to liability in tort, both for duty of care, breach of duty, and causation. So if it has said that, well, in nervous shock, it does not depend on foreseeability alone, then what does it depend on? Tell us what it depends on. Okay, so you know that of course there is the problem, the challenge of using foreseeability for nervous shock, the floodgates arguments. So, and then you tell us what the special rules that have been designed to cater for liability for nervous shock. You are talking about all these situations with your relevant cases or statutes or whatever. If you don't use your cases, you are just expressing your opinion. Your opinion will not count in law. So you give us the cases where these tests have been designed and defined, have been explained to answer your question, and your discussion will be reversed. A question like this is standing alone, just like the first one, and that's the question that is expected to take like 20, 30, 25 minutes, depending on how many hours you have for your exams. So you mean that it requires a lot of you from you. I also have another question here that says, in accordance with changing social needs and standards, new classes of persons legally bound or entitled to the exercise of care may from time to time emerge. It is a quotation, and it says by Equity LJ in Chandler and Crane Christmas Company. Explain this statement in line with the legal connotation of the tort of negligence. You see, the examiner is very kind to you, but you could have just said explain. And if you did not pick this statement when you were studying, I said pay attention to details, to statements, to opinions of judges. If you don't pay attention, you will not pick it and know the area of the law that it is with that area relating to. But the examiner has been so kind as to say Discuss, explain the statement in line with the legal connotation of the tort of negligence. So what is the tort of negligence? That's what it's about. And of course, you know, as a starting point for the tort of negligence is what that statement has said about duty of care, exercise of care. So tell us what is tort of negligence. Tell us the elements required there. There's a duty of care, there's a breach of duty, and there is a damage. Then pick the idea of the duty of care, because that's the focus of channel equity. The LJ statement says new classes of persons. So what classes of persons do you hold a duty of care? Of course, you know that you cannot answer this question without talking about Donoghue and Stevenson and how duty of care is formulated and the categories of negligence. And I think that a good student, an excellent, a first class student, will not forget to mention that popular saying that the categories of negligence are not closed, because that is what Equity LG was saying in this statement when he said that new classes of persons may emerge from time to time, because the sort of negligence is about human interactions, about development. So as society develops, as we become more technologically inclined, mechanical and whatever, new classes of people that you hold a duty of care would emerge. So it tests your knowledge, the understanding of the conceptualization of the tort of negligence, and relevant authorities must accompany your answer. Your cases will be popping, your laws must be, statutes will be popping as you answer your law exams. I'll also look at another question that says, discuss the defense of contributing negligence to an action in negligence. Now, this is a very straightforward question, because I said today, of course, we are dealing with essays. So if you say discuss contributory negligence, you need to tell us what does the defense of contributory negligence mean? What is the meaning? How does it function? How does it work under the tort of negligence? Everything you know about the defense of contributory negligence should come into this answer, because it says discuss the defense in a negligence action. So everything you know about it, the meaning, the differences between it, and highlight defenses like maybe voluntary non-fit injuria and any other concept that you think is near to it, whether it's a full defense or a partial defense. Tell us everything you know about this defense, and it's an A section of an answer. So you will know also where to draw the line, because you are going to divide your time to answer this B part, which is a problem question that I will be taking in subsequent presentation. And finally, there is a question here that says, the popular saying that finding is keeping is a dangerous half-truth, which needs a good deal of expansion and qualification to make it square with the law. I repeat, the popular saying that finding is keeping is a dangerous half-truth, which needs a good deal of expansion and qualification to make it square with the law. So it says, comment on this statement and examine the extent to which a finder of a chattel is entitled to it vis-a-vis the owner of land where the chattel is found. Now, don't always forget, when you have your problem, an essay question, you must read the question underneath the question. What did they ask you to do? So it says comment on it. So you might say, okay, so it's testing your knowledge of another field of law in the law of tort. So which field of law is it testing? And that is why when you are reading, you must read with your topics in mind. Read with your topics. Don't just pick information everywhere. Know that I'm reading trespass to goods, I'm reading conversion, I'm reading tertinu. Under tertinu, these are the key points. These are the major cases. Under trespass, over conversion, these are the key points. This is general rule about conversion. These are the forms of conversion. Oh, when it comes to finders keepers, which is talking about which kind of issue in law, you must be able to say it. So this says it's a dangerous half-truth. Do you agree that it's an half-truth, which needs a good deal of expansion and qualification? So it's saying that is not an absolute rule, that there are some exceptions to it. So yes, finding is keeping generally, but there are some situations where finding is not keeping, and the examiner has been so kind to you to say discuss this vis-a-vis when it is the right of the owner. So between the finder of a thing and the owner of the thing, where the owner of the land where the thing is found, whose claim has preeminence in tort, who is entitled to keep the thing, as against, of course, also the owner of the thing, the person who has lost something. I've lost my gold chain when I came to a party at Airport Hotel, which is a public place, or I came to a party in the house of my friend Banke which is a private place. When I left, they found this chain. Chain was found by another visitor. Caller wants to keep the chain. Banker says, no, it was found in my land. I want to keep the chain. Or I come around and they've not even found me. Let's leave me, the owner, out of the equation. So who is entitled in law? And you know that there are cases in this area that are very robust. So you need to dissect that statement. Every time they give you an essay statement, dissect the statement. Look at what they want you to do with the statement. Tell us you agree with it. Is it correct? Is it not correct? Is it the absolute rule? Is it an exception? And you'll be good to go. Don't forget, you must pay attention to your cases. There are locus classicus cases in these fields that I have discussed with you. In the next presentation, we'll be looking at some problem questions, in terms of creating a structure for answering them. And I believe that with this, you'll be able to sit down and answer some of these questions with the right content. Because what I've just done is to give you the structure that I've talked about earlier, that when you enter the exam hall, you give a structure to your answer so that you can guide your recollection and what you put down. Now we've gotten some structures into those essay questions. Let us begin to practice them, to simulate the exam conditions and find the answers to them. See you at the next presentation.